The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 931, coming to you on Monday the 25th of March 2019. On this program, I will speak to you on the topic, the Election Petitions Judgement. But before I get into the topic, a very short preliminary comment. As usual, my condolences go out to families which have suffered recent bereavements. And in that connection, let me say special condolences to the families of Miss Joanne Ballantyne of netball fame and Mr. Decent Henry, who is a prominent Vincentian who died in England, and also the families of another Vincentian who died in England, Mr. Leo Jack. That is his family in England and his family in St. Vincent and the Grenadines. As promised in last program, or 2 programs ago, I wish to read for you excerpts from the closing pages of the judgment of Mr. Justice Stanley John in the election petitions cases. That judgment was delivered on the 21st of March, accompanied by much fanfare on the streets of Kingstown. You will recall that there were actually 2 petitions, and therefore there were 2 cases. But for hearing purposes and the purposes of the judgment, the cases were consolidated. That is, they were tried together, heard together, and one judgment was given covering both cases, but with commentary by the judge on each individual case. The cases featured quite a number of lawyers, both local lawyers and lawyers from the region. And I would like to now give you the names of the 8 lawyers who were involved on the side of the 2 petitioners and the 11 lawyers who represented what I'd broadly call the government side. The petitioners' lawyers were 1, and this is not in order of ranking and seniority, but just in order of their appearances given. 1, Mr. Bertram Commission QC. 2, Mr. Keith Scotland. 3, Mrs. K. Bacchus Batiste. 4, Mrs. Zingerhorn Edwards. 5, Mrs. Sharon Morris Cummings. 6, Ms. Sherlyn Zeta Banwell. 7, Miss Maya Eustace. And 8, Mr. Stanley John QC. The lawyer representing the respondents, of whom there were 8 respondents, the lawyers on the government side were Mr. Douglas Mendes, SC, Mr. Michael Quamina, Mr. Joseph Delves, Ms. Rena Batiste, Mr. Dwayne Daniel, number 5. Number 6, Mr. Carlos James. Number 7, Mr. Anthony Astafan, SC. Mr. Kendrickson Kentish, number 8. Number 9, Mr. Richard Williams. Number 10, Ms. Danielle France. And number 11, Mr. Kezron Walters. The final hearing of the petitions after previous proceedings in the High Court, in the Court of Appeal, and again in the High Court, the actual petition, the substantive hearings, lasted for 9 days, plus the day when judgment was delivered. So they took up 10 days of court time. In the interest of time, I will go right over to paragraph 141 of His Lordship's judgment and read you the closing pages. The judgment ran up to 174 paragraphs, and the transcript of the case, the judgment ran to 63 pages. Quite voluminous indeed. But for those of you who don't have access to the internet, where the judgment has been printed on the Eastern Caribbean Supreme Court website, I would encourage you to listen carefully to my reading. I will not be commenting on anything the judge said. I will simply be telling you what the judge said. There have been enough comments by many people on these petitions. A lot of the comments by people who are not even present when the petitions were heard. Here goes, paragraph 141. The judge said, "A good starting point is the onus of proof. Unlike civil and criminal proceedings, in election petitions, there is no burden of proof placed on either party. In the case Saifi versus the governor of Brixton Prison, the court observed that the absence of a reference to any standard was deliberate. Quote, "It leaves the matter open and untrammeled by rigid evidential consideration." Paragraph 142. At the core of the statutory provisions governing the conduct of parliamentary elections in St. Vincent and the Grenadines is the intent of Parliament to ensure that the democratic will of the electors prevail, that the candidate representing the choice of the majority of the electors be returned as the duly elected member. To this end, legislators have prescribed the manner in which the democratic will must be expressed. The following dictum in the case Re Tanjon Puteri Dahori is instructive. Quote, and this is what the judge in that case said, "To my mind, an election does not merely symbolize the citizens' right to free franchise, but entails public participation in selecting the government of their choice through a process which not only guarantees absolute fairness, secrecy, impartiality, and regularity, but which also encompasses public trust and confidence in the manner in which the process is carried out. For these reasons, various legal guidelines have been enacted to regulate the formalities of an impartial election. Any serious departure from these procedures will strike at the very foundation of our free and democratic system of political representation and affect public confidence in the impartiality of our election." Unquote. Then His Lordship, Justice John, continued, paragraph 143. "Under the common law, an election could be vitiated if the court is satisfied that either of two grounds was present: that there was no real electing at all, or that the election was not really conducted or subsisting on the election laws. In St. Vincent and the Grenadines, the court is of the opinion, and so holds, that there are two streams by which an election could be invalidated: under the common law and by operation of the enabling provisions of the Representation of the People Act. Excuse me. Paragraph 144. In Woodward versus Sasson, the common law grounds were explained by Lord Coleridge, Chief Justice, by formulating two specific questions. In respect of the first ground, Lord Coleridge said, quote, "As to the first, the tribunal should be so satisfied, that is, that there was no real electing by the constituency at all, if it were proved to its satisfaction that the constituency had not in fact had a fair and a free opportunity of electing the candidate which the majority might prefer," unquote. Paragraph 145. As to the second ground, that is to say, the election is not conducted under subsisting election laws at all, Lord Coleridge formulated the question in this way, quote, "The question must be in like manner whether the departure from the prescribed method of election is satisfied, that the election is not an election under the existing law," unquote. Paragraph 146. Lord Coleridge provided examples of situations which would satisfy each of the grounds to which he alluded. Examples of the first ground included the instances where the majority of electors were prevented from voting by general corruption or general intimidation, or by the unavailability of the materials for voting according to law. Lord Coleridge also included fraudulent counting of votes or false declaration of numbers by returning officers. Is paragraph 147. A stark example of an election which was, quote, "no real election," unquote, occurred in 1874 in the case of the borough of Hackney. In that case, many polling stations had been closed for the entire day. As a result, 5,000 people were unable to vote, and the election was invalidated under Section 13 of the Ballot Act of England, 1872. Paragraph 148. On the second ground, Chief Justice Lord Coleridge provided examples of an election not conducted according to law. An example provided by the learned Lord Chief Justice was where, with the consent of the whole constituency, a candidate was selected by the tossing of a coin. Such election would be by the free will of the people, but not according to law. The learned Lord Chief Justice had this to say, quote, "It is not enough to say that great mistakes were made in carrying out the election under those laws. It is necessary to be able to say that either willfully or erroneously the election was not carried out under those laws, but under some other method," unquote. Paragraph 149. At length, the learned Lord Chief Justice circumscribed the power of the court to declare an election void in these words, quote, But if in the opinion of the tribunal, the election was substantially an election by ballot, then no mistakes or misconduct, however great, in the use of the machinery of the Ballot Act could justify the tribunal in declaring the election void by the common law of England. Paragraph 150. Accordingly, the Lord Chief Justice locked the jurisdictional door where there was a finding of substantial compliance. If there was substantial compliance, the court would not be justified in declaring the election void. Paragraph 151. In the case of Gunn versus Sharp, 1974, the failure of officials to stamp ballot papers constituted substantial non-compliance, since the error disenfranchised more than half of the voters. By contrast, the court in Borough of Drogheda in 1874, found that there was substantial compliance even where polling stations were opened 45 minutes late, since not a single voter had been prevented from voting and the whole community was polled out. Paragraph 152. In the case of Finch versus Stevenson and others in 2008, a petitioner was a defeated candidate at a local election. The first respondent was the returning officer for the election, and the second, third, and fourth respondents were the successful candidates. It was common ground that only 4,930 of the 9,099 votes cast in the election were counted for the purpose of declaring the result, and it was not disputed that the failure to count the remaining votes did not affect the result. However, the petitioner contended that the failure to count what amounted to 45.8% of the votes constituted such an irregularity in the conduct of the election that it could not be said to have been conducted substantially in accordance with the law as to elections, contrary to Section 48(1) of the Representation of the People Act 1983. He issued an election petition. The respondent argued that there were procedural flaws in relation to the petition which were not amenable to amendment, and thus they contended the petition should be struck out. Paragraph 153. In the course of delivering her judgment, Mrs. Justice Cox said, quote, "The decided cases, including those which Lord Denning considered in Morgan and Simpson, establish that the courts will strive to preserve an election as being in accordance with the law, even where there have been significant breaches of official duties and election rules, providing the result of the election was unaffected by those breaches." Excuse me. Paragraph 153. The learned judge then referred to the cases of Marshall and Gibson and Harris and Gilmore. In the former case, Justice Coleman, given the judgment of the court, said as follows, quote, "The effect of Section 48(1) of the 1983 Act is that an election will not be declared invalid merely because there has been a breach of official duty in connection with the election, or by the rules by the returning officer or any other person. There cannot be a declaration of invalidity unless it appears either that the election was so conducted that there was substantial non-compliance with the law as to elections, or that there was a breach of official duty or of the rules which affected the result. It is clear now that the result means the question which person or persons are elected as distinct from the number of votes cast for each person. Thus, if the consequence of a breach of the rules is that one or more of the candidates would have polled more or less votes than were recorded at the count, but the same candidate or candidates would still have been elected, the result will not have been affected, and the election can only be declared invalid if it appears to the court that the election was not so conducted as to be substantially in accordance with the law as to elections. Paragraph 155. And let me break here to indicate that I still have another several pages to read. 1, 2, 3, 4, 5 pages and a bit. And with the remaining time, I would not get through 5 pages and a bit. I think I will get through the bit and possibly 1 page. And therefore, we will take the break when the time is up. And by the will of God, I'll come back next week, Monday, to read the rest of it for you. But it is important that you hear what the judge actually wrote, and not what people say about what he wrote or how people interpret what he said. I am reading to you what the judge wrote, and I'm not going to affect what the judge wrote by giving you any comments of my own. So let me turn now to paragraph 155. That case was followed by Harris and Gilmore, in which a number of breaches of the rules occurred in the conduct of the count and in dealing with the ballot papers following the count. Justice Morbick, giving the judgment of the court, described them as serious breaches of duty on the part of the deputy returning officer, but held nevertheless that they did not mean that the election must necessarily be declared invalid. It was possible on the evidence to ascertain with confidence exactly what happened to the ballot papers between the completion of the original count and the recount. After referring to Section 48 of the Representation of the People Act and to the decision in Marshall versus Gibson, the court expressed itself satisfied that the election was conducted substantially in accordance with the law, and that the breaches of the rule did not, in the event, affect its result. Paragraph 156. The locus classicus in the region on the true meaning of substantial compliance continues to be the judgment of Chief Justice Rawlings in the case Quinn Leandro versus Jonas, where he had this to say, quote, "An election court would not invalidate an election on the ground that there was substantial non-compliance with electoral law pursuant to Section 32(4) of the Representation of the People Act, if the breach of elections procedure stipulated by the law was trivial. There had to be such a substantial departure from elections procedure stipulated by law that would cause an ordinary person to condemn the election as a sham or travesty. A considerable departure was required. Accordingly, an election court would usually only invalidate an election on that ground if the judge was really satisfied that the breach was serious. Paragraph 57, and I will stop at the end of paragraph 57. Later on at paragraph 180 of the judgment, Chief Justice Rawlings said, quote, "However, I think that for good reason, the authorities seem to show that where there is evidence that includes statistical data and other relevant information from which a court may determine, even inferentially, that the breach did not affect the result, Proposition 4 is not to be applied without first attempting to determine whether the result was affected. This is because an election in a democratic society is for the purpose of determining the will of the voters. The court must seek to determine this as far as it is possible when an election is challenged." The time being up, I will stop here, which is in the middle of paragraph 157. Let me make a note as to where I have got to. And next Monday, DV, I will continue reading the judgment of His Lordship, Mr. Justice Stanley John, in claim number 202 of 2015 and 203 of 2015, brought by Laurent Baptiste and Benjamin Exeter, respectively, popularly known as the election petitions. But perhaps in a few seconds, I can read you the very last paragraph of the judgment. And it's important. The judge said, final paragraph, "This case has highlighted the need for proper training of persons who perform official duties in elections. That, the court believes, will alleviate the many irregularities which have arisen in this case." So the judge, throughout the case, found that there were many irregularities in the conduct of the election in the two constituencies. In other words, many things were done wrong or not done at all, which should have been done. So it is not true for anybody to say that the judge said he didn't find any irregularities. Throughout the case, he said he discovered many irregularities, but the point he made was that those irregularities together were not so serious as to nullify the election in either of those constituencies. So in short, he said, yes, there were irregularities, but they could not result in nullifying or declaring void the election in any of the two constituencies, Central Leeward or North Leeward. That is all from this program of The Law and You, in which I read you excerpts from the judgment in the election petitions case. I look forward to continuing with the reading next week, Monday, Divi, when I bring you another presentation of this public service nation-building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.